When Jasmine Crockett walked into Judge Richard Leon's courtroom, the state was ready to crush her. But instead, she went straight at their defense, tearing into their claims, exposing what they never expected to see daylight, and forcing a tense, head-on confrontation that pushed Leon to the edge of his bench, left the state's attorneys visibly unraveling, and turned the entire hearing into a live constitutional showdown no one in that room could look away from. The courtroom felt tight before a single word was spoken. Rows of wooden benches were packed shoulder to shoulder, reporters balancing notepads on their knees, community members whispering behind their hands, and attorneys scanning documents like soldiers checking gear before a fight. This wasn't just another federal hearing. It was a high-stakes voting rights showdown unfolding inside the United States District Court in Washington, D.C., where a controversial state election law was about to be tested under the harshest legal spotlight. The moment the bailiff called out, "All rise," the sound seemed to snap through the courtroom like a starter pistol. Conversations died mid-sentence. Papers stopped rustling. Even the air felt tighter. Judge Richard Leon strode in without looking left or right, his reputation arriving a half-second before he did. Lawyers called him the Hammer because he didn't just question arguments. He broke them apart in public. Then Jasmine Crockett stood up, alone. No assistants, no mountain of binders, just a thin manila folder in her hand. As Crockett walked past the clerk's desk, the clerk leaned in and quietly warned, "Judge doesn't tolerate rambling. He'll cut you off fast." Crockett didn't slow down. Her expression didn't change. She stepped to the podium like someone who had already decided how this was going to go. Judge Leon watched her closely, his eyes narrowing just slightly, the look he gave when he expected a weak opening. "You may proceed, counsel," Judge Leon said, voice flat but loaded with expectation. Crockett opened her folder slowly, not rushing, letting the silence stretch just long enough to pull the room toward her. When she spoke, her tone was calm, but her words hit hard. "Your Honor," she began, "the state is asking this court to pretend that inconvenience isn't suppression, that closing doors and calling it policy somehow makes it legal." The temperature in the room changed instantly. A few heads snapped up. The state's lead attorney shifted in his seat. Crockett continued, her voice steady but sharper now. "They've dressed discrimination in neutral language and hoped no one would bother reading the fine print. But when a law blocks citizens in practice, calling it security doesn't make it honest. It makes it camouflage." The gallery went dead quiet. Judge Leon leaned forward slightly, eyes locked on her. Then Jasmine Crockett didn't rush into legal theory. She walked the court straight into the real-world impact first. "Your Honor," she began, steady and controlled, "this case isn't about paperwork. It's about what happens when policy meets reality." She explained how the voter ID requirement looked neutral in statute books but operated very differently on the ground. Entire communities now had to travel hours to reach the nearest licensing office. For working families, that meant lost wages. For elderly voters, it meant physical hardship. For many, it meant simply giving up. She laid out turnout data with surgical precision. Neighborhoods that once voted reliably, now showing dramatic declines. "When access collapses this sharply," she said, locking eyes with the bench, "we're not looking at inconvenience. We're looking at functional exclusion." Pens stopped moving in the gallery. Even spectators who came expecting legal jargon found themselves leaning forward. Judge Leon cut in abruptly, his voice sharp enough to slice the rhythm. "Counsel, difficulty does not equal illegality. States are allowed to regulate elections." It was the kind of interruption that had rattled seasoned attorneys before. Crockett didn't flinch. "Absolutely, Your Honor," she replied instantly. "But regulation crosses a constitutional line when the burden becomes selective. The question isn't whether the state can regulate. It's whether it can do so in a way that predictably locks out lawful voters." The speed and clarity of her response reset the tempo. Across the aisle, the state's lead attorney rose halfway from his chair. "Objection. Argumentative framing." Crockett turned slightly, already anticipating the move. "Your Honor, I'm establishing burden analysis under existing precedent. Judge Leon flicked a glance at the state attorney. Sit down. She's within bounds. A quiet ripple moved through the room. The early attempt to slow her momentum had failed. Crockett pivoted smoothly to numbers. Fraud, the justification the state leaned on, was almost non-existent. She cited verified cases over a decade compared to total ballots cast. The ratio was microscopic. We are restructuring access to protect against a statistical ghost, she said bluntly. And the cost of chasing that ghost is being paid by lawful voters. Judge Leon interjected again, testing the edge. Fraud prevention remains a valid interest, counselor. Crockett nodded. Yes, Your Honor, and Supreme Court precedent makes that clear. But the same framework demands balance. State interest versus citizen burden. When the burden overwhelms the justification, the regulation fails constitutional scrutiny. Her cadence was controlled, but her words carried weight. She wasn't arguing in circles. She was tightening them. Then she reached into her folder and unfolded something larger. A color-coded map spread across the podium, bright against the courtroom's dark wood. With the court's permission, she said. Judge Leon gestured once. Crockett turned the map outward. Red zones marked communities where large portions of voters lacked the required ID. Blue dots showed licensing offices. The imbalance was immediate. Entire red regions with barely a dot in sight. The gallery went silent in a way that felt physical. Even the state's attorneys leaned forward. These red areas, Crockett said calmly, are where the burden lands. Travel distances reach triple digits. Office hours conflict with working schedules. This is not abstract. It is measurable access denial. No one spoke. The room is silent. Crockett let the silence from the map settle before she spoke again, and when she did, her tone shifted. Less argument, more revelation. Your Honor, she said, what you're seeing didn't come from a think tank or a theory. It came from people who were told, in effect, that voting was now a privilege with a price tag. She described traveling community to community, sitting at kitchen tables, listening to voters explain why they'd been turned away. A single mother who couldn't afford to lose a day's pay to chase paperwork. A veteran who assumed his identification would be enough, until it wasn't. Crockett wasn't dramatizing. She was cataloging. Each story had been cross-referenced with census data and geographic access points. We didn't assume a burden, she said evenly. We measured it. The courtroom could feel the weight of that phrase. This wasn't rhetoric. It was groundwork. Even Judge Leon's posture changed slightly, his earlier skepticism giving way to focused curiosity. Her voice remained steady as she pulled the narrative backward in time. 6 months ago, she continued, we started mapping patterns. Every denial, every closed office, every district showing abnormal turnout collapse. She described overlaying community reports with transportation routes and office hours, building a data model that showed the law's impact wasn't random. It was concentrated. Across the aisle, the state attorneys flipped through their binders faster now, scanning for counterpoints that weren't landing. Crockett didn't pause. When the same communities consistently absorb the highest burden, she said, you don't call that coincidence. You investigate intent. A few spectators exchanged looks. The tone had shifted from defense to exposure. Judge Leon noticed it too. He leaned back slightly, eyes narrowed. Not dismissive, but recalibrating. Then came the deeper layer. Crockett explained how her team filed targeted Freedom of Information Act requests. Not broad fishing expeditions, but precise document pulls focused on policy drafting communications. We reviewed thousands of pages, she said, line by line, metadata included. Her delivery was calm, but the implication was sharp. This wasn't guesswork. It was excavation. The gallery sensed the tension rising again. This wasn't just about impact anymore. It was about what might have been written behind closed doors. Crockett paused just long enough to let that realization breathe. Judge Leon's gaze stayed fixed on her, and for the first time, he spoke without interruption in his tone. "Counsel," he said, quieter now, "you're suggesting deliberative intent?" Crockett met his eyes directly. "I'm saying the paper trail answers questions the statute avoids." Her next words carried a flash of narrative, a brief look behind the curtain. "During our review," she said, "we flagged internal correspondence that didn't match the public justification. Language choices, timing inconsistencies, strategic phrasing. She didn't overplay it. She didn't need to. The suggestion alone tightened the room. Even the state's attorneys stopped shuffling papers." Crockett continued, measured but firm. "We were advised to tread carefully," she added, "because exposing internal policy logic can unsettle institutions." The understatement landed harder than a dramatic claim would have. Judge Leon studied her expression, searching for exaggeration. Finding none. Her confidence wasn't loud. It was grounded. The suspense hung thick now. Crockett closed her folder slowly, like someone preparing to change the temperature of the room. "Your Honor," she said, voice level, "the evidence speaks for itself. But context matters, and context is written in the documents." Judge Leon's tone shifted when he responded. "If you have something material," he said, leaning forward again, "the court will consider it." That subtle change, from challenge to invitation, didn't go unnoticed. Crockett nodded once. "Then with the court's permission," she said, lifting a sealed set of papers, "I'd like to approach the bench." The room went still. No whispers, no movement, just anticipation. The courtroom air tightened as Crockett stepped toward the bench, the sealed document steady in her hand. Every eye followed her. When she returned to the podium, she didn't rush. "Your Honor," she said, voice level, "this is an internal communication obtained through lawful discovery." Papers slid softly as copies were handed up. Judge Leon unfolded the pages with the practiced calm of someone who had seen everything, until his eyes stopped. A faint crease formed between his brows. The gallery leaned forward instinctively. Crockett spoke again, carefully. "Page 3, middle paragraph." The judge read silently for a beat, then his gaze sharpened. A murmur rippled through the room before anyone even knew what the sentence said. Judge Leon looked up, then, deliberately, read the line aloud. The words landed heavy. Language suggesting the policy would disproportionately impact a targeted demographic while maintaining plausible deniability. The gallery reacted audibly this time. A mix of disbelief and low gasps that bounced off the wood-paneled walls. Across the aisle, the state's lead attorney shot to his feet. "Objection, Your Honor. Procedural irregularity." His voice came too fast, too loud. Crockett didn't even glance at him before responding. "Your Honor, this document was produced in discovery by the state. Its authenticity is not disputed, and its relevance goes directly to intent." Judge Leon's eyes never left the page. "Sit down, counsel," he said evenly. The command wasn't raised. It didn't need to be. The state attorney hesitated, then tried again, scrambling. "Your Honor, the context—" Crockett cut in, precise and controlled. "The context is preserved in the chain, which is included in the court's copy. The language is explicit." The interruption wasn't emotional. It was surgical. The judge flipped back to the paragraph, rereading it more slowly, lips pressing thin. The room felt suspended. Even the spectators seemed to forget to breathe. What moments ago looked like a confident government defense now felt brittle. The authority that had filled the state's table drained visibly, shoulders tightening, eyes darting, papers shuffled without purpose. Judge Leon set the document down with measured care. "Counsel," he said to the state's attorney, "this language raises serious questions." The attorney opened his mouth, then closed it again, clearly recalculating. Crockett stood still, letting the evidence speak louder than any flourish. The psychological balance had flipped. The state's position, once anchored in procedural confidence, now looked exposed in open court. The gallery sensed it. A public unraveling not of volume, but of credibility. Crockett didn't press. She didn't need to. The email had already done the work. After a long beat, Judge Leon's gaze returned to Crockett. "Miss Crockett," he said, tone sharpened by focus rather than anger. "Assuming this communication reflects intent, the court must examine whether the regulation survives strict scrutiny." The words settled over the room like a signal flare. Crockett stepped back to the podium, shoulders squared, voice steady. "Your Honor," she began, "even if fraud prevention is accepted as a compelling interest, this regulation collapses under scrutiny because it is not narrowly tailored." She didn't rush the phrase. She let it land. The burden falls overwhelmingly on lawful voters who did nothing wrong. When a law solves a speculative problem by imposing measurable harm, it fails the tailoring requirement. Across the aisle, the state's lead attorney shifted in his chair, already flipping pages, searching for footing that wasn't there. Crockett continued, laying out alternatives like stepping stones. Secure digital verification, expanded ID access programs, mobile licensing units, all less restrictive, all previously proposed and ignored. "The state didn't choose the least burdensome path," she said plainly. "It chose the most convenient one for itself." Judge Leon came in fast, voice cutting through the air. "Counsel, hypothetical. Suppose a state adopts a neutral verification system that incidentally affects travel time for certain districts. Does incidental burden alone invalidate the rule?" Crockett answered before the echo faded. "No, Your Honor. Incidental burden is tolerable. Systemic exclusion is not. The Constitution tolerates inconvenience. It does not tolerate structural disparity." Another hypothetical followed immediately. "What if fraud risk increases tomorrow?" Crockett didn't blink. "Then the state responds with proportionate measures supported by evidence, not preemptive restrictions unsupported by fact." The rhythm felt like a sparring match, but Crockett wasn't dodging, she was intercepting. Each answer arrived clean, precise, leaving no loose edges. The state's attorney tried to interject. "Your Honor, counsel is oversimplifying." But Judge Leon silenced him with a raised finger. The room felt electric. Even spectators unfamiliar with legal doctrine could sense controls shifting in real time. Crockett pivoted back to intent, voice steady but sharper now. "And when the justification is pretextual," she said, "the framework collapses entirely. The evidence shows fraud was not the motivating factor. It was the shield." The phrase hung in the air. Judge Leon stared at the bench copy of the documents, then back at Crockett. For the first time all morning, he didn't speak immediately. The silence stretched, not awkward, but heavy. Attorneys in the gallery recognized it instantly. A rare judicial pause signaling impact. Even the state's table stopped moving. Crockett didn't fill the silence. She let it do its work. Then she opened her folder again. "Your Honor," she said quietly, the calm in her voice somehow louder than anything before it. "There is one final piece of evidence the court should see." Heads lifted across the room. The state attorney's jaw tightened. Judge Leon's gaze sharpened. The silence snapped into anticipation. Crockett handed the sealed memorandum to the clerk, who carried it to the bench with exaggerated care. The courtroom was so quiet you could hear paper slide against paper as Judge Leon opened it. His eyes moved quickly at first, then stopped. The change in his expression was subtle but unmistakable. Crockett spoke evenly. "Your Honor, this is a confidential internal report from the state's Election Security Division, dated 2 weeks before the law was enacted." Judge Leon reread the paragraph, slower this time. The conclusion was blunt. No meaningful evidence of in-person voter fraud. The justification that anchored the state's entire defense. Gone in a sentence. A collective breath swept through the gallery. The state's attorney shot to his feet. "Your Honor, we request a recess to review this document. Judge Leon didn't look up. Denied. The word landed flat and final. Counsel, he continued, eyes still on the memo. Is this an authentic internal report? The attorney hesitated. I would need to verify, Judge Leon cut in. You will verify now, on the record. Papers rustled frantically at the state's table. Crockett didn't gloat. She framed it clinically. Your Honor, the memo directly contradicts the public rationale for the regulation. This is not oversight. It is institutional inconsistency. The phrase hit harder than accusation. It suggested structure, not mistake. Judge Leon set the memo down carefully, as if it carried weight beyond paper. This document, he said slowly, strikes at the core of the state's position. The atmosphere changed. Even casual observers could feel the trajectory bending. The state's confidence, once visible, now looked brittle. Crockett stood motionless, letting the record speak. The courtroom wasn't reacting with noise anymore. It was absorbing consequence. Then Judge Leon looked up at her, and something rare crossed his expression. Recognition. Miss Crockett, he said, voice measured. The clarity of your presentation materially alters how this court views the state's justification. It wasn't praise for theatrics. It was acknowledgement of impact. The room felt the shift. What had begun as argument was now reckoning. When the state's attorney returned to the podium, the confidence that once framed his posture was gone. His voice carried strain. Your Honor, he began, while the memo raises questions, it does not negate the legislature's authority. Judge Leon interrupted immediately. Counsel, answer directly. How does the state justify imposing this burden when its own security division found no meaningful fraud threat? The attorney faltered. Policy decisions involve... Yes or no? The judge pressed. The corner tightened. The attorney finally admitted carefully that the memo conflicted with the public rationale. The gallery stirred. It wasn't loud. It didn't need to be. The admission hung in the air like a verdict preview. Crockett's rebuttal was brief, almost quiet. Your Honor, she said, this case was never about abstract authority. It's about whether constitutional protections yield to unsupported claims. The record now answers that question. She didn't embellish. She didn't repeat herself. She simply closed the loop. When she stepped back, the courtroom fell into a deep, collective silence. The kind that signals recognition. Observers exchanged looks that said the same thing. The outcome felt inevitable. Judge Leon looked across the room slowly, then struck the bench once. The court will take the matter under advisement. His tone carried finality, but the tension didn't dissipate. It settled. As Crockett gathered her folder, reporters were already shifting in their seats, aware they had witnessed a turning point. When she spoke one last time, thanking the court and redirecting attention to the voters affected, the emotional center of the case snapped back into focus. It wasn't victory she emphasized. It was consequence. The gavel came down again. Court is adjourned. No one moved immediately. The silence lingered, heavy with the sense that something historic had just unfolded. Not through volume or spectacle, but through precision. 3 weeks later, Judge Leon's ruling dropped, and it landed like a legal shockwave. The opinion halted enforcement of the voter ID restrictions, calling out the mismatch between the state's justification and its own internal record. Voting access protections were restored almost immediately, and election officials were ordered to implement fairer procedures. Within days, lawmakers in other states began reassessing similar policies, wary of facing the same constitutional scrutiny. What had started as a single courtroom fight now carried national weight. The legal community reacted fast. Analysts broke down the ruling as a blueprint for evaluating intent and burden in election law. Law schools circulated excerpts from the arguments as teaching material, highlighting how preparation and factual precision reshaped the case. Advocacy groups cited the decision in fresh challenges, and several jurisdictions quietly reversed or softened comparable rules. In the next election cycle, turnout in previously restricted districts rebounded noticeably. A practical reminder that courtroom outcomes can echo directly into civic life. The story's final note wasn't about spectacle. It was about discipline and principle prevailing under pressure. A single hearing, built on preparation, evidence, and constitutional clarity, reset the balance between power and accountability. In the end, the memory that stayed with observers wasn't the noise or the clash, but the silence after the arguments. The moment a courtroom became the birthplace of restored rights. If this courtroom battle kept you on edge, don't stop here. Stories like this show how preparation, courage, and principle can change real lives. Subscribe for more powerful legal showdowns and moments where the fight for rights unfolds in real time. Because the next case might be just as historic.